Hi, good afternoon, and welcome to WG University, Weber Gallagher series of educational programs. This is our workers' compensation webinar series. I am Mark Gallagher, and seated next to me is David Assalone. We're both in the Philadelphia office. Each month, we present current topics in workers' compensation. We present case law updates, and we also present ways for you to manage the risk inherent to your business. At the conclusion of this webinar, if anybody would like to share it with others or see it again, you can go to our website, wglaw.com. You will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is everything you needed to know about subrogation but were afraid to ask. Next month, our topic will be calculating Section 40 lien rights in New Jersey workers' compensation cases. So without further ado, let's take it away. So Dave, what are we presenting today? What do you have?
All right, good afternoon, Mark. As Mark stated, we are talking about subrogation in Pennsylvania workers' compensation today. There are several topics that we are going to cover today. We'll give you a quick overview of the topics. First, generally, we will talk about what is subrogation. After that, we will talk about these several bases or reasons for having subrogation in the workers' compensation system. We will get into the fact that the right to subrogation under workers' compensation law in Pennsylvania is absolute, although there are several exceptions, and we will get into those. So absolute is in quotes there. We will discuss the exclusivity provisions and immunity that employers are afforded under the Pennsylvania Workers' Compensation Act. We will discuss specifically and probably particularly for this audience how subrogation and subrogation lien recovery works. We will go through the different potential limits on subrogation recovery, and we will also provide you with a quote-unquote employer's to-do list of different actions that should be taken by the employer and by its employer, or excuse me, the employer and its attorneys in securing those subrogation rights. And finally, probably most practically, we'll talk about several different examples about how to handle having a subrogation lien right, whether you want to compromise that lien, whether you want to assert the full lien, or whether you want to waive that lien entirely. And finally, at the end, we'll give you a brief example of the third-party settlement agreement, LIBC 380, which is one of the forms that we use exclusively in finalizing third-party settlements. So with that, Mark, let's talk about what is subrogation generally.
Well, in general, Section 319 of the Pennsylvania Workers' Compensation Act provides that exclusive right inherent to the employer and or carrier, depending on who's paid out the funds. And it basically states, as you can see on the screen, where the compensable injury is caused in whole or in part by the act or omission of a third party, the employer shall be. And let's stop right there. Whole or in part. It doesn't have to be entirely the fault of the third party. It can just be part of the third party's responsibility for whatever injury occurred. They're still responsible for the subrogation lien interest of the employer or the carrier. And then the other word, shall be subrogated. That's mandatory language. This is not may. It's not a maybe it happens, maybe it doesn't, right? It's an absolute right inherent to the employer and or carrier. The balance of that goes on to explain what entities an employer or carrier could seek reimbursement from when in the event that there is a compensable subrogation lien. And it's to the extent of the compensation payable under this article by the employer, which includes both wage loss benefits and medical benefits for a subrogation lien.
Let me ask you then, Mark. We're talking about wage loss benefits paid by the employer. We're talking about medical benefits paid by the employer. How about litigation costs? How about unreasonable contest? Are those included here, or are we limited to medical and wage loss benefits?
Medical and wage loss benefits, anything that's punitive against the employer would be excluded. And any litigation costs that occur by the employer in order to secure this recovery is also not compensable. The statute's pretty specific in that respect.
Okay. Now, when we're talking about subrogation, specifically under Section 319 of the Act, it's not as if the employer, if there's a subrogation lien, can recover the entirety of that lien due to the fact that the third party is putting in work, especially their attorney, in securing the third party settlement or securing the third party verdict. according to the Act, reasonable attorney's fees and other proper disbursements incurred in obtaining a recovery or effecting a compromise settlement shall be prorated between the employer and the employee. So, frankly, what that means, and we'll get into it a little more specifically later, is you have to find out, taking a look at what the overall workers' compensation lien is and taking a look at what the overall third-party settlement is, you have to determine what proportion the workers' compensation lien represents compared to the third-party settlement. And then based upon that percentage, there's going to be an apportionment or a pro rata distribution of some of the third-party costs against the employer. So what that really means in practicality is if you had a $50,000 workers' compensation lien, you wouldn't ultimately be able to recover the entirety of that lien. You'd have to take into account the third-party costs and attorney's fees.
And just to jump in real quick, this attorney's fees and proper disbursements, that can get a little bit muddled if you have more than one defendant. Construction case would be a perfect example. Every time I say construction case, there's multiple defendants, and oftentimes there's a defense verdict in favor of a defendant. You don't have to reimburse costs that are associated with litigation by the plaintiff or claimant against the defense verdict defendant. There's also the flip side of that. For calculating your lien, you don't get delay damages. You don't get to subrogate against that. You don't get to subrogate against post-verdict interest. Just a couple little things that you need to pay attention to when you get delving into these subrogation liens.
Now, the final section of 319 of the Pennsylvania Workers' Compensation Act indicates that, and this is pretty straightforward, that any recovery against a third party that's in excess of the workers' compensation lien, so in excess of the employer's lien, that amount shall be directed to the employee or to the employee's representative, if it's a decedent case, to the decedent or their family. But essentially, we're dealing with the subrogation of the amount of the workers' compensation lien. Anything over and above that will go to the claimant or claimant's family, with some exceptions that we will discuss in a moment.
To put a little more street parlance onto that, there's two pieces to a compensation lien. One is what you've paid in wage and medical benefits. That's called the accrued lien. What this section here speaks about is what's called the future credit. It's either stuff that you haven't paid yet for which you have a credit because the recovery in a third-party case was so large. So two pieces to a lien. You always have to keep that in mind, especially if you're going to go and compromise on a lien, is that there's an accrued lien, again, what you paid, and a future credit, what you may not have paid, what you may pay in the future. Just keep that in mind as we discuss this going forward.
Now, there are several reasons or bases for subrogation, and most of them really do kind of intermingle with each other. But first and most important, the basis for subrogation is to prevent a claimant from obtaining essentially a double recovery for a work injury or incident. We call it double dipping in our business. The idea there is, as this is a no-fault system, the workers' compensation system, the employer, the insurer, is paying for any compensable work injury. So they're receiving both wage loss and medical benefits through the comp system. If the claimant then goes out as a plaintiff and files a separate third-party action and they're recovering there, the idea is to prevent essentially the recovery from both the third-party case and the recovery from the workers' compensation case, i.e. double dipping.
For those of you who've been around for a while, anybody remember the Motor Vehicle Financial Responsibility Law? In that law, it was specific subrogation for workers' compensation carriers was specifically excluded from any recovery under the Motor Vehicle Law at the time. That was subsequently changed, I believe, in Act 43. It's been around. You see one, it's a real old case, because I think Act 43 came in about 1993. So just that really is, that double dipping thing was an issue in years gone by. It's not so much nowadays, with a few exceptions. What else do you have up there, Dave?
So similar to the double dipping idea is the workers' compensation system is a no-fault system. So you want to have, when there is an acknowledged and compensable injury, you want the employer to pay promptly. You want them to be able to pay the wage loss benefits that are needed. You want them to be able to pay the medical benefits that are needed immediately without having to actually determine liability for the actual incident. So the other two reasons for subrogation are you want to make sure that the employer, while they may have to pay at the onset, that they're not actually the ones that ultimately are responsible when there is a third party tortfeasor, when there is a third party that actually is responsible. And then on the other flip side of that, you want to make sure that the person or party responsible for the injury or accident is the actual party that's paying for it. So while the employer has to pay at the onset, ultimately subrogation allows kind of a sway and to allow the actual liable party to pay the cost that they should pay out.
Mhm. Well, as you can see, it's an absolute right to subrogation. The primary thing to look at there is that last sentence where it says unless expressly waived. When we talk about subrogation being an absolute right, the legislature meant it. Remember the shall word that they used in the statute? So it's an absolute right, but you can give it up. And that's where it becomes a necessity to know what you're giving up. If I were to say, well, we waive our entire subrogation lien, does that mean you waived your accrued lien and your future credit? Or does it mean you just waived an accrued lien? How about if you have a document that's not so specific and you say, well, I'll waive this part of the lien, thank you very much, send the rest of it, and you don't specify what exactly you're waiving. Did you waive the future credit? It's something that you need to be very cognizant of, and the treatises on subrogation suggest that all of us need to be very careful with the language we use in any third-party settlement agreement. And with respect to waiving, there's a number of ways to do it. You can do it in a compromise release agreement. You can do it in part in a third-party settlement agreement, but the one form we haven't mentioned, which is almost always necessary when we're dealing with recovery subrogation liens, is a supplemental agreement. We didn't attach it to this. It's a pretty easy form to find, but you can use it, and it's actually recommended that you do use it to account for future credit. So just keep that in mind. You really need to be careful if you're going to waive or compromise in any respect all or part of your subrogation lien. Okay?
And we'll talk about this, but would you say 100% it would be the right move to always, if you're going to waive a lien or you're going to compromise the lien, to do that in writing?
Absolutely. And in fact, the courts have said that you have to do it in writing. You don't just give a handshake and off you go, and you've done something that you're not permitted to do by law. You have to put it in writing, and were you not to do so, you'd be foolhardy. So, writing's a good thing, and that supplemental agreement is really the ticket here. There's other ways to do it, but that's the main one.
And as Mark said, this is an absolute right, but there are exceptions to this absolute right, and although it is an absolute right, the employer, the insurer, always has the opportunity, because it's their right, to compromise the lien or to waive the lien, and we'll talk about that a little bit in further slides. So give us an idea, Mark, about the general exclusivity provisions of the Act and what that really means for how that applies to subrogation.
Well, since the compact came into play, the idea was that an injured worker would only be able to come after his or her employer with a workers' compensation claim. You could not bring a general liability claim. The idea was to prevent runaway verdicts like you may see in a general liability case, and to give the employer a finite exposure, which presumably can be calculated and insured. It bars third-party tort actions against the employer. The employer has immunity from common law liability for work-related injuries, with perhaps two exceptions. One involves intentional conduct that's basically tortious, it may be even criminal, engaged in by an employer. That might very well give rise to a third party or direct liability action. The other one is what's known as the dual capacity doctrine. I used to see this with a company that I represented that cuts down trees. We also had a manufacturing wing that was a separate corporation that made the chippers, the things that throw the wood in the back and little chips come out the other end. Well, when one of their workers or two of their workers got sucked into the chipper, somebody claimed that the chippers were negligently manufactured and had a products claim. That's a dual capacity, because one corporation, despite being under the same parent corp, was the employer. The other corporation was the manufacturer of the chipper that sucked in the wood and the person. The other way that you see this come up is in medical facilities. I have a daughter that's a nurse. She works at a medical facility. She slips and falls on the floor. Of course, it's a compensable injury, and it's covered by workers' compensation, and she can't sue her employer. Well, let's change that for a second. Let's say that she slips and falls and she gets hurt. They treat her in the emergency room. The emergency room doctor engages in negligent conduct. Now what do you have? You have a medical malpractice claim, arguably against the doctor and the hospital, because they've now acted in a dual capacity. Again, I bring this up just you need to analyze these when and if you see a subrogation case. So with that, let's move on to the next slide. See what we
Sure.
have.
So, as Mark was discussing, the exclusivity provisions of the Act allow or limit an injured employee, in the ability to sue its employer, his or her employer. So, the only way to get compensation is through the Pennsylvania Workers' Compensation Act. Now, how that applies to subrogation, as Mark stated, this protects employers from civil litigation suits when their employees are injured. And as we discussed before, as this is a no-fault system where the employers don't actually have the opportunity to determine if the claimant was at fault, if an additional party was at fault, they have the opportunity to, well, first off, they have to pay out the money. And obviously we're talking about workers' compensation cases, and you can get into the whole litigation of was this a compensable injury or not. But generally, if an injury occurs in the course and scope of employment, it's a compensable injury. So we don't get to challenge whose fault the injury was. So in subrogation, while the employer might have to foot the bill at the onset, it allows them to foot the bill at the onset with the knowledge that maybe later and down the line they can seek subrogation and get their money back, or at least part of it, from the responsible party.
How subrogation works. Doesn't matter if the case is settled or a judgment or verdict is awarded. It doesn't matter how that's allocated, pain and suffering, economic damages, monetary damages, as long as there's a reward payment of some type. Even in the face of a settlement where there's no admission of liability, the employer is still subrogated if the underlying facts are due to the work-related injury. That can change a little bit if you're in a medical setting. I'm not going to go into that because it's a pretty specialized field. There are a few cases floating around that would suggest that depending on how the settlement is apportioned, there may be a way to step around the workers' compensation setting, but it's very, very, very limited and perhaps not applicable here. And the tortfeasor, you don't go after the tortfeasor. That would be a mistake because you'd have to prove the tortfeasor was responsible to the employer. And the cases speak to if you go up to tortfeasor, employer can't recover. It goes with that. Employer doesn't have their own right. They actually step through the employee. And in this particular instance, the employer always steps through the employee. The employee has a right to bring the suit. So that kind of leads us into the next slide, if I'm not mistaken.
Yes, so as Mark was stating, the employer does not have what we would call a direct right of action against the third-party tortfeasor, the responsible, negligent, liable party here. The only way subrogation works is for the employer to step, quote-unquote, into the shoes of the claimant. So it's the claimant who is the one that needs to file the third-party action for liability or negligence, whatever purposes, against the third party. If they recover from the third party, then it's the employer that can, through the shoes of the employee, seek subrogation. So unfortunately, there is not this direct right of action. You have to wait, in most regards, for the employee to actually file the third party suit, and whether they ultimately settle that case or whether they take that case to verdict and prevail, that is the way that the employer can go ahead and seek subrogation recovery.
It's sort of a spin on that. That's all very true. I've seen examples where the plaintiff claimant with their attorney comes to the employer and says, can you foot some of the bill so we can get experts because this is a very expensive case, and you stand in line to recover a substantial amount of funds from workers' compensation if we are successful. Another thing that I've seen done but very infrequently is intervening. Generally, you might see it down in federal court where you file an intervention action so that you, as the employer carrier with the subrogation lien, is on notice of everything that's transpiring in the court. Saw that more years ago. More recently, the federal judges just jump right in and call you. So do the local judges because they'll want to settle something and they want you to compromise your lien, which we'll get to. And I can tell you from very recent experience with a federal judge calling an adjuster, as the first time the adjuster ever got a call from a federal judge, the uh, the adjuster was flabbergasted. In fact, I think quaking in his boots. It turned out, fortunately, I knew the judge. The judge was just trying to shake the tree and see if he could get his case settled with a compromise of the workers' comp lien. We're close. It's not done yet, but there's ways to address it. We're in the process of doing it. Just a couple things to keep in mind.
Mark, let's skip ahead to the employer's do's and don'ts, because you did mention some very important points there. First off, when you are the employer and you are aware that there is either an actual third-party case pending or you believe that there's a potential for a third-party lawsuit, and that's pretty clear. I mean, in some scenarios, the employee will slip and fall in your building. They didn't slip and fall on anything. There's no potential third-party action. But for instance, one of the most common examples is a motor vehicle accident. The employee is traveling in the course and scope of their employment for their employer, and they're rear-ended by another party. So in that case, even if you don't specifically know that a third-party action is filed, you do know that there's a potential for a third-party lawsuit. So the first thing I think any employer should do in that scenario is they should put the claimant's attorney, if there are other parties actually in the third-party action, such as the defendant and the third-party defense attorney, you should put them all on notice that you have a pending that you have a pending workers' compensation lien, and that you have the right to subrogation against it.
You absolutely should do that. We call it a Section 319 letter, which is the subrogation section of the Act. You basically just write, say, look, we're paying workers' compensation, wage, and medical benefits pursuant to the Workers' Compensation Act, Section 319. We have an absolute right to be subrogated in the event that you achieve an award by settlement, verdict, or otherwise. We're entitled to be paid before a dime is paid out. That's all true. There's the Pennsylvania Professional Rules of Conduct for Lawyers requires that those funds be escrowed, but you need to send that Section 319 letter just to cover yourself. One of the first things you do whenever there's an issue with a workers' compensation claim, we have a law firm here, and people run around a law firm all the time. Let's say somebody slipped and fell on a wet floor and gets severely injured. They're the employee of the firm. It's the firm's responsibility to pay comp, but the firm doesn't clean the building. So there's a third party. Automobile cases, who struck who, red light, green light, that kind of stuff. Who's the offending party? Can you subrogate? Construction cases, who shot the nail gun, the nail that ricocheted off of something, it wasn't one of your employees. You have a subrogation case. You have somebody in a manufacturing facility. I have one, actually speaking with somebody today, federal court, there was a problem with a saw, and the saw had been modified a little bit, somebody lost an arm. That's who they're going after, the manufacturer of the saw. Not the manufacturer, but the manufacturer of the saw. I have another one where a gentleman lost a leg driving a stand-up forklift, got caught between a steel pillar and a revamped factory storage area. That pillar used to be inside a storage rack, so you couldn't hit it. So the plaintiff's lawyers are looking to see, one, if the tow motor's bad, so they can sue them, and that's everybody chain of distribution from the manufacturer on down. And then number two, they're looking to see who the architect and the engineers and the builders were for that steel pillar that's encapsulated that the leg got caught between. And this guy completely lost his leg. It's 475 weeks, I think, of wage loss benefits over and above what he's currently claiming as a site claim. So you can do the math on, max comp rate, what's 875 or whatever it is for this year. It's a lot of money. And so that everybody's looking to get that third party. It's something you have to take a look at. And I say that because I probably would need a bunch of my fingers on more than one hand to tell you the number of times people tell me that there's nothing going on, we don't have a suit, and then I find out later that, well, yes, there was.
So that's a good segue there, Mark, because not only should you first and always put the claimant's attorney on notice that there is a workers' compensation subrogation lien and that you have the right to it, but the employer's attorney or the employer, most likely the attorney, they should periodically monitor that third-party case. It's not enough to just take the word of the claimant's attorney that there is no third-party case, because frankly, sometimes it's not the same counsel. Sometimes the claimant is represented in the workers' compensation case by one attorney, and then in the third-party civil liability case by another party. So you can't just take them on their word that there is no third-party claim. Here at Weber Gallagher, we generally do civil docket and criminal docket searches kind of as a matter of course, and those are things to somehow, sometimes even if they say they don't have a case, you see on the civil docket that there's a third-party case pending. So you not only want to give them notice or put them on notice, but you want to periodically check on the status of the third-party case because that's money that you could potentially get back.
Absolutely. There's the other thing for those of you in the insurance business, you can index these folks and see if something popped up from whatever your case may be. I don't know what procedure is to do it. You do it on your end, and I see the things.
Right, the ISO claim search, right.
But I've seen third-party cases pop up that I otherwise would not have known about. It never hurts to keep an eye on this stuff because everybody's just out there looking to get things done real quick. And without
And before we go to some of the limitations on this, Mark also mentioned one other good point I wanted to highlight here. Most attorneys, really by the professional rules, have an obligation to, if there's any third-party settlement, to escrow those funds. Once they're put on notice and they know that there is a potential workers' compensation subrogation lien out there. Whether they do that or not is up to them, but they should put that money aside because they are not permitted to just distribute any third-party settlement funds to the claimant or plaintiff and to themselves without taking the workers' compensation absolute subrogation right into account.
Okay.
So let's talk about some of the limits, because although we say this is, quote, an absolute right to subrogation, there are some limits on recovery.
So statute of limitations is one. If the claimant plaintiff doesn't file within the statute of limitations, sorry, employer and carrier, you can't do it yourself. Comparative negligence really doesn't mean anything if the claimant plaintiff is found to be comparatively negligent. And what that does in a liability setting, if there's comparative negligence assessed against a plaintiff, their reward is reduced by the amount of negligence found. That doesn't have any effect on your subrogation rate. You still get to subrogate against what they get.
Let me ask you this, Mark. If you have a third-party case and the employer, although not but maybe a party to the action, but the employer is found to be partially liable for the negligence.
Doesn't matter.
Does that mess up your right to subrogation?
Doesn't matter. That's part of what the compact exclusivity provisions are. Employers are negligent all the time, unfortunately. I mean, it's a lot of times what causes an injury. That doesn't reduce or otherwise negate the employer's subrogation lien. The big one on here is the spouse's loss of consortium claim. You'll oftentimes see plaintiffs' lawyers trying to apportion a settlement, or if they can't do it with a lawyer because a jury speaks or a judge speaks, but when they're settled, they try to apportion a great big portion of the recovery to the loss of consortium claim. You don't have, as a carrier or an employer, you don't have a subrogation claim against that. That's something to keep an eye on, and it raises a red flag if it goes much above 10 or 20% of an award. There's issues with children in a fatal claim setting. If mom is collecting fatal claim benefits and the children pursue a wrongful death action, there's no subrogation against that wrongful death action because the children don't take comp benefits in their own right. They take it through mom. The existence of children just increases the amount of money that mom can get, or dad if dad's the widower. Just a little something to look at. That can change depending on what the kid's status is. If mom passes away and the kids now have a right, or mom remarries and the kids now have a right to collect in their own right, there may be a subrogation interest at a later date. So you have to keep these things in your front window, I should say. You have to keep an eye on them.
Okay. So you told us about the spouse and the loss of consortium. In a similar regard, the pain and suffering is another issue to watch out for. Claimants or plaintiffs' attorneys may try to apportion, most likely in a settlement situation, not so much in a verdict scenario, may try to apportion the third-party settlement to pain and suffering, which is something different than what an employer can recover, because they can recover the money for medical benefits and wage loss benefits. But just like in the loss of consortium cases, the courts have given an eye to this, and they're very mindful of any cases where the large majority, or it looks like the plaintiff's attorney is trying to apportion money to pain and suffering versus to wage loss and medical benefits. So that's something to keep in mind. But generally, it's frowned upon for them to try to say all the settlement is for pain and suffering versus for medical and wage loss benefits.
Just real quick, political government involvement, it's specifically excluded if there's recovery against a governmental entity or statute that says you can't recover. Motor vehicle accidents, that's more of an issue of uninsured motorist benefits. Right. Since I see we're running a little late on time here. That all depends on who has the insurance. If it's the claimant plaintiff's insurance, there's no subrogation. If it is the employer's insurance, there's subrogation, but you're basically stealing from one pocket and putting it in another. Just a little something that you need to pay attention to.
So all these things, these are just potential limits. Each fact pattern may have, a different determination in this regard. These are all things, though, that you should definitely keep in mind. As Mark said, political government involvement, you can't get any subrogation, but most of the rest, there are some potential limitations on your absolute right. So let's move ahead to practicality. What do you do, Mark, with your subrogation right, your lien?
You try to enforce it to the extent that you can, but what invariably happens, if you have an open comp claim, they want to compromise something, and you want to take a step back, take a look at what your procedural status is, where you are in paying for the claim, what your exposure is on the claim, and what you can realistically expect to see coming out of the third party. There's many, many variations of it. Bottom line is, you shouldn't compromise or release any part of your lien unless you're getting something back of value. Usually what you'll see is you compromise part of your lien as part of an overall settlement package. You don't make the same recovery you would have otherwise if you just stood on your rights and say, I get all the money. But that will facilitate your efforts to settle the comp claim, which in a lot of instances has a far greater value than a lot of these little motor vehicle cases. It's just the way that it is. There are other times where you need to be, I guess this is kind of a practice tip. I couldn't tell you the number of times I've had an attorney tell me that the liability case stunk. They don't have any liability. They don't have enough damages, and it's not worth much. Compromise your lien so that we can achieve a recovery. I invariably ask one question: what offers do you have on the table? And I found they wanted about 90% waiver, a rather large lien, about $500,000. They settled the case for about $1.5 million, and their offer on the table at the time was $900,000. So query, why would I compromise that lien? I mean, ultimately, we gave up a little bit of the lien, but we gave it up in order to get a compromise release out of the workers' compensation claim. The workers' compensation claim is put to rest. So that's really what you're looking for, is you're looking to minimize your exposure. Whether you stand your ground and collect the lien, whether you don't stand your ground, it's always part of our efforts to reduce and mitigate the employer and carrier's exposure.
And just adding to that, as Mark said, there's a couple of variations. I mean, there's actually quite a few variations on this. You can have scenarios where you've settled the workers' compensation case first, and a third-party settlement comes down the line. There's scenarios where you're trying to settle everything comprehensively, one big settlement, and there's settlements where you have the third-party settlement first, and you have to figure out what to do with it. So, as Mark said, you have many options. You can either maintain your full subrogation lien, you can compromise the lien to an extent, whether to effectuate a total settlement, to maybe put a little bit more money in the claimant's pocket, maybe to potentially reduce the overall compromise and release settlement. Sometimes if you reduce the amount that you're going to get back on the subrogation end, you may be able to settle your workers' comp case for less money, no money. It all depends on the particulars.
It's a moving mass. There's a lot of interchangeable parts. I recently settled a case for quite a few $1 million. One of the issues came up. There's a third-party case that is being pursued. It's a products case. It looks like it has some traction. Will we waive our subrogation lien? The answer was a resounding no. We will not waive our lien. Why? Because the kid's he's a paraplegic. He wasn't quad, but he's getting back his legs. Thank God. There's just a lot of moving parts to it. It's hard to give you a one rule fits all in this. You have to look at your facts, you have to look at your exposures, you have to look at the facts of the third-party case, take a look at what kind of money's floating around, and then you have to make an informed decision. And as the judges like to say, when we mediate cases, when you walk away from the table and nobody's happy, that's usually a good deal.
All right.
So,
And invariably, as Mark said, the claimant's attorney, the third-party attorney, even the judges sometimes in the third-party cases, mediating judges, they're going to come to you and they're going to want you to compromise your lien. Just because they want you to compromise your lien, though, doesn't mean you have to. As if anything has been made clear here, this is an absolute right to subrogation. It is a right that is afforded to the employer. It's up to the employer, its insurance carrier, and through the work of counsel to make that determination of whether you maintain the full lien, whether you compromise it, or whether you waive it all.
just one comment before we close here, because I think we're a little over time. We're not going to go into a third-party settlement agreement. You can take a look at it. There's a lot of different numbers. There's a lot of different permutations. There's actually another way to calculate. There's two ways to calculate, which we're not going to go into. Just a practical pointer, judges like to call you up and jump up and down a holler and scream, whether the Court of Common Pleas or whether they're federal judges, and try to rally you and try to get you to do something you don't have to do. They can't force you to settle, but what they can do is they can order you, at least they can order me, to come into a courtroom. The one thing you don't want to do is ignore the judge. Play nice, play by the rules, and evaluate the case. Say, yes, we can do it. No, we can't do it. If here's something in the middle. And if you pay attention to the facts, the details, these things usually work out, and usually in favor of the employer carrier, to be quite honest with you.
And I would just add, Mark is 100% spot on when he says comply with the judge, but the right to subrogation is through the workers' compensation system. And the workers' compensation judges, that is the line where they are the ones that have authority over subrogation. A Court of Common Pleas judge does not have the right to make the determinations on subrogation. It actually goes exclusively through the workers' compensation system. So while you should be polite, while you should do everything you can do to be in the judge's good graces, especially in the common pleas arena, it is the employer's right to subrogation. It is ultimately your determination whether you want to compromise it, waive it, or assert the full thing. So we've attached at the end of our slideshow a copy of the third-party settlement agreement. This is a Bureau Form LIBC 380. We won't go through the particulars with the numbers on this, but this is generally the preferred form. As Mark mentioned, there are other ways to calculate third-party settlements and subrogation. But if you have any questions, please feel free to contact us. We're happy to help you out in this regard. And a third-party settlement agreement, a supplemental agreement, the C&R agreement, these are all useful documents that can be used to, in writing, effectuate the third-party settlement.
Hey, listen, thanks everybody for joining us at WG University. We hope this helped. And again, feel free to forward questions to us.
And just so everyone knows, this was our webinar, Everything You Need to Know About Subrogation, but We're Afraid to Ask. Our next program will be on August 15th from our New Jersey office, entitled Calculating Section 40 Lien Rights. Our New Jersey attorneys will explain Section 40 lien rights, when they apply, consideration for waiving the right, and how to calculate. You can learn more about this program and all other Weber Gallagher events at www.wglaw.com/WG-University. Thank you, guys.